Good morning, everyone. The Court of Appeals is now in session.
Good morning and welcome to the Court of Appeals today. It's very nice to see your faces and we look forward to hearing your arguments today. Mr. Clark, are you new? Are you new to the Court of Appeals or have you appeared before?
Oh, this is my first time, so you'll have to go easy on me.
We will for sure go easy on you. I'm sure you're familiar with how the clock works and how this all works, but I'll just go over a little bit of a few of the details to help us all remind us. I think we are getting close to actually being done with our WebEx hearings. We might be back in person at the end of the summer. So everybody keep your fingers crossed. That would be awesome. And just to start out, this is in the case of the interest of CN, state of Utah, and the minor CN. Counsel, would you please enter your appearances for the record before we begin?
Lindsay Wheeler for the state.
And Alex Clark for the defense.
Awesome. And that each side has 15 minutes in which to make its arguments. It appears, Mr. Clark, that you've reserved 4 minutes for rebuttal.
That is correct, Your Honor.
And just specifically for these virtual hearings, if you are not arguing, if you would please turn off your camera and mute your microphone, that will allow the judges to be able to focus on the attorney that's making arguments at the moment. We will also mute our microphones. I think we found that helps with bandwidth unless we have a question. And if we do have a question, we'll try to get your attention by unmuting our microphone and maybe, making a noise or a motion. Do you have any questions before we begin, either one of you?
I do not, Your Honor.
Perfect. Then, Mr. Clark, please begin when you are ready.
All right. Thank you, Your Honors, and may it please the court. In this case, the juvenile court erred in convicting CN, my client, of the offense of rape of a child without there being any evidence of sexual intercourse. And so the juvenile court judge in this case, in finding that CN was guilty of rape of a child, based his verdict when he's on the finding that the alleged victim in this case was credible. The bulk of the evidence in this case was a CJC interview with the alleged victim when he was 9 at the time. And in that interview, what the interviewer asks probably 35 times what occurred, and about 18 times in that interview, the CJC interview, the alleged victim says something to the effect of, I placed my middle thingy in her butt. The her being the CN, the defendant in this case. And so 18 times and consistently throughout, the defendant says something to the effect of, she told me to put my middle thingy up her butt. They ask, well, okay, what did you see? He says, I saw her butthole. They say, what do you feel? He says, I felt her butthole. And so throughout consistently, go ahead.
Can I ask a question?
Absolutely.
It was a little unclear to me from your briefing whether or not you contend that to have rape of a child, it has to be vaginal intercourse. Does sexual intercourse require vaginal intercourse?
So we do bring that up, and it's kind of we don't fully address it head on, but it's inferred in this. And in our brief, we do say that yes, we believe that, and right now I'm saying that yes, sexual intercourse does require, or sexual intercourse requires vaginal intercourse. And there's a couple of reasons for that. Number one, just based on kind of the canon of when we interpret statutes, we don't infer that the statute intended there to be surplusage. So we do have in Utah a statute that addresses sodomy on a child, and in that it talks about any sexual act upon or any sexual act involving the genitals or anus of the actor or the child and the mouth or anus of either person. And so when interpreting that statute, we would think that the legislature, when it made it, or when it created that it didn't intend that that a rape of a child, that sexual intercourse covered both kind of sodomy and vaginal intercourse. We would assume, we would argue that, and did I miss a question or no? Yeah, so we would just assume that, by interpreting that statute, that means something different than rape of a child. And there's also cases, that they are old, that talk about how it requires, I think it was Taylor, and it requires both the male organs and the female organs, which would not include the anus. Go ahead.
This court, though, in Hattrich, which I think is in 2019 case, at least in rejecting an ineffective assistance of counsel claim, at least acknowledged that it's possible that statute covers both anal and vaginal intercourse. And you, in your brief, cite to a dictionary definition of sexual intercourse, which includes both. So I'm just wondering, do we have authority in this state that says if a statute potentially two statutes cover the same act, that we are supposed to read the one as excluding one of those acts? Or, do you have a case you can cite me to say that that's how we should be reading sexual intercourse in this case, because we do have that other sodomy statute?
Yeah, so I think number one, I would say that that issue, we do bring it up, like you said. I would, number one, we would welcome further briefing on it. I don't believe that the state, in their answering brief, contends that at all. And so we would welcome further, because, like you said, we did kind of reference it. But I think, let's see, I have in my notes here. So in State v. Warner, and that's the one that I was referencing. So it may not answer your question about whether or not you have the authority to interpret it. But in that one, it does say to constitute the offense of sexual intercourse, there of course must be an actual contact of the sexual organs and a penetration into the body of the female, the insertion of the male organ to an extent into the female organ. And so, but we would welcome further, if you would like further briefing on that specific issue. So again, we do raise it, and we do talk, kind of reference it in our brief, but was not answered, or it was not replied to or argued against in the state's brief. But we would welcome further argument on that. So,
Mr. Clark, can I ask you this question? Given that, I know you just cited Warner, but statutorily, penetration is not required to prove sexual intercourse. Only that any touching, however slight, occurred, and that is 76-5-407. Does this distinction between rape and sodomy actually matter? Like, in the sense of, since penetration was not required, and there's evidence, testimony by SD that there clearly was touching going on down there. There was clearly, if you believe him, and the juvenile court certainly did believe him, thought that he was credible. There was touching. We don't know how slight or what, but there was touching going on there. Is that enough to sustain the conviction here?
So no, and for this reason. So the rape of the child statute, as you said, it kind of talks about how any touching satisfies that, right? But I would say that if we were interpreting that, we would have to infer or imply that the touching requires, the vagina in this case. It may not need the penetration, but when it says any touching, it can't mean that, well, touching your face or touching someone's, stomach or something like that. It's implied in there that there's a specific place, and in the sexual intercourse, I mean, that is the only element other than in a rape of a child statute. There's sexual intercourse and the age of the child. And so we would argue, and we argue that when it talks about a touching, it absolutely does matter where it occurs, because it's not just any touching anywhere. Implied within that is the touch, sexual intercourse, touching of the vagina. And again, it doesn't, like you said, it does not require penetration, but it does require that the contact between, a penis and a vagina. And so we would say absolutely it does matter. Sodomy and that statute talks about something completely different. It talks about either the genitals or the mouth and the anus. And so we would point to that. And so the judge, either, in this case, the judge either, number one, believed incorrectly that that sexual intercourse included anal sex, or he got the facts wrong in this case, because the facts show repeatedly, consistently, and with great specificity, that the alleged victim said, basically, I placed my middle thingy in her butt. That was an anatomically correct reference that is consistent throughout. And the state kind of argues, well, there was this police officer who said, well, yeah, but in some cases, kids, they don't really know. And sometimes when they say the word bottom, they really mean vagina because they're not sure. But number one, the police officer, he had no, all he was doing was he was watching the CJC interview, number one. Oh, go ahead.
Let me ask you about the investigator. So if I remember right, there was no objection made to his testimony on this issue. Is that right?
That is correct.
And so, I appreciate the arguments made in the brief about him not being qualified as an expert, perhaps, or maybe this not being testimony on which he could give expert testimony. But if no objection was made, and you haven't argued that was error for the court to not refuse to consider that testimony, wasn't the court entitled to rely on this opinion by someone who has experience to say that this is common for children to refer to a vagina as a butt or a bottom, or, I don't remember exactly his testimony, but why isn't that appropriate for the court to rely on that when there was no objection made?
So it's inappropriate for the court to rely on it. It's not so much that we're saying that there was some sort of 602, 702 violation. It's more, we're arguing that what he said was a nothing burger, basically, because he number one, he wasn't established as an expert witness, and so that there was no objection to that, because I don't believe there was an attempt by them to do that. And so, and what it's basically the analogy in this case would be if someone someone testified and said, I was assaulted. If this was an assault case, and they said, I was punched in the face. I saw someone's fist. I saw the knuckles. They said they were going to punch me, and then they punched me. And then a police officer who then listened to that statement say, well, yeah, he said that that he got punched in the face, but in my experience, a lot of times in assault cases, there's an assault with a weapon. And so, and looking at the way that his face bruised, I think it was actually a bat that was used. And I think that when he said that he was punched in the face with his fist, he actually meant that he was hit in the face with a bat. I see that my time's over. And so I think that sufficiently answered your question. If not, I can further go.
Well, let me ask it this way. So here we have the child who testified what it felt like when he inserted his penis into CN. And then you've got the investigator testifying that it is common for children to confuse these terms, which I think a judge could reject as an unreasonable piece of testimony, but could also potentially accept. And so if you put those two things in combination, where the description that he gives is consistent with inserting his penis in her vagina, is it insufficient evidence for the court to rely on those two things in combination to conclude that a rape here occurred, even if the court's only looking for vaginal intercourse?
Absolutely, it is, because everything that he says is consistent with anal, placing his penis in her anus. And so you have to speculate that, well, yeah, he said this, but you have to speculate. Okay, number one, even though he's a 9-year-old boy, and at the time of when he testified at trial, he was 12. I guess he doesn't know what a butthole is. And number two, you'd have to speculate that. You'd have to speculate that, well, a butthole is not soft, which the state does not prove, and it's not the defense's burden to prove that. And so everything that he says is consistent with it. And just the fact that he said, well, it was soft, that to me, that does not then change everything he said about what he saw, what he saw, what he was told to do, what he said he did at both 9 and when he was 12. And so to say, well, but he said it was described as soft, even though everything else is consistent with placing his middle thingy into her butthole, to me, it requires speculation, which speculation that is absolutely insufficient evidence. There's a reasonable doubt about which one occurred. And so I don't want to go too farther, but if that answered your question, then I will reserve the rest.
Thank you, Mr. Clark. Ms. Wheeler?
Good morning, Your Honors Counsel. May it please the court, Lindsay Wheeler for the state. I think I'd like to pick up a little bit where Mr. Clark left off. I'd like to start with defendant's 702 argument that the officer needed to be qualified as an expert. And first, defendant raises that claim for the first time in a reply brief, so this court shouldn't even reach it. The state didn't have the opportunity to completely research that issue and to brief that issue because it is raised for the first time in her reply brief. That said, it does appear that that testimony is invited error, and I would direct this court to page 816 of the record, where defense counsel elicits the testimony from the officer when she asks, quote, "So how did you narrow it down to vagina?" By watching the video. What was it specifically that made you narrow it down to vagina? And the officer answered, quote, the victim's description, quote, "It felt like it was soft when he put his penis in there." That said, I'm not sure that 702 even applies. This isn't scientific, technical, or information that really requires particularized knowledge. It's information that's most adults know based on human experience. And had this been testimony that the prosecutor elicited and defense counsel had properly and timely objected to, the officer would have been readily qualified as an expert. He was a 21-year veteran. He'd been assigned to sex crimes for a quarter of his career. 5 years of that, child sex crimes. He had been trained to administer the CJC videos, and he conducted numerous interviews of children. So he's well versed in how children describe their body parts, how children discuss these matters, and recognizing that this was an age-appropriate description of vaginal sex. If there's no questions about that, I'd like to move on to the sufficient. Yes, Your Honor.
But is that true? And isn't it the state's burden, kind of like we said in Patterson, isn't it the state's burden to ask those specific questions? If there is any question about whether the elements of the offense have been proven, isn't it the state's burden? Shouldn't a 12-year-old boy, it would seem, as you were saying, a 9-year-old boy maybe could be confused or not able to describe body parts particular way, but a 12-year-old boy should definitely, it seems like a 12-year-old boy would know the difference between anus and a vagina. And wasn't it the state's burden to ask that next question?
If I'm understanding the court's concern, and I want to make sure I get it right, basically, why didn't the child who testified about it one way when he was 9 have better descriptions of what happened to him when he was 12, and why didn't the prosecutor ask those questions? Well, first, I'm not a pediatrician, right? But I think that really this was a child that was recounting what had happened to him using the same terms that he had first recounted it. And his memory maybe was stuck in the same spot. I'm not quite sure. But his description was still age appropriate. And defense counsel questioned him on cross-examination about his memory of it. And he remembered his memory 3 years later, although he did not remember a lot. What he did remember was very much in keeping with his CJC video. It was consistent throughout. And his age-appropriate descriptions when he was 12, that's still an age-appropriate descriptions. It's still a child recounting their first sexual experience, either on video to a stranger or during cross-examination to a stranger. And their ability to maybe recall the body parts of the opposite sex could be hampered by that as well. But yes, Your Honor.
I'm gonna actually ask, did I cut off your thought? If you want to finish your thought, do that, because I'm gonna change gears on you a little bit.
I would like to change gears from this. Yes, Your Honor.
I'm not saying that. I didn't want to interrupt your thought if you weren't. It seems, would you concede that to at least some extent, in order for the court to get to a guilty verdict here, it had to make some inferences?
I don't want to be too picky here, but this wasn't a guilty verdict. This was an adjudication.
No, I understand that. Yeah.
So I do want to be clear about that. I think the court did have to make an inference, but the court did make a reasonable inference here. And this is a juvenile court, which this court has recognized time and time again that sits in an advantage position with this type of evidence and children's testimony. And the juvenile court listens to children testify and talk about these sorts of actions, unfortunately, quite a lot, and has a good sense of how children describe these events.
Let me ask you where I wanted to actually go is, if that's true that the court's making inference here, and I agree with you that it has to, because the testimony is not as clear as it could be. And I'm not staking out a position that it's not clear enough. I'm just getting to this point. In deciding whether the inferences the court appears to be making are reasonable, should we be taking into account the testimony which appeared to be consistent between all witnesses as to the positions of the victim and the perpetrator during the act? In other words, if what they describe positionally becomes more unlikely, does that undermine the reasonableness of the inferences that are made? Do you understand my question?
I think so.
And let me be more pointed and just frank. He was approaching her from behind, so that seems to make more sense, just in one way, that what we were discussing, what he was actually talking about would be anal intercourse rather than vaginal. So do you think that's something we should consider?
I think that the juvenile court heard that testimony as well. And the juvenile court, even in its findings, which were sparse, recognized that we were talking about a bunch of youngsters who were recounting what had happened. And the juvenile court interpreted that testimony along with the victim's descriptions of supporting the sexual intercourse finding. And I think that there's some evidence that the victim was more on top of the defendant's back and less and less of a straight angle, if you will.
Okay, well, if that's your answer, doesn't it make what the trial court concluded less probable?
I don't think so, Your Honor, because the trial court heard that evidence as well as all the positional evidence, along with the victim's testimony that it felt soft all around inside, that the defendant moaned while he inserted his penis into her vagina, and that they look like an animal connected together with a stick, and his stick was his penis, and all of that supports the finding of vaginal sexual intercourse.
No, I read that in your brief, and frankly, I don't follow that. I do understand the point about something feeling soft, and especially where you've got your investigator indicating what that means to him, and maybe the court piggybacked its inferences based on that. But how would this looking like two animals connected, how would that be different in vaginal intercourse versus anal intercourse? I don't understand how any inference between the two is made by that.
I think it more goes to the evidence as a whole, Your Honor. And what we have is a 9-year-old boy who's describing apt descriptions of sexual intercourse that he wouldn't know unless it had happened to him and unless he experienced it. And based on the presentation of the evidence as a whole, it supports the element of sexual intercourse. And here, this was a victim who...
I guess my question's going more to the point of there seems to be little doubt that from any of the testimony or anything in the record that some sort of sexual touching occurred, but how moaning or appearing to be two animals hooked together would indicate vaginal versus anal intercourse is hard for me to follow.
And then I think this court can focus on the victim's description of what happened. It felt soft all around, and then the officer's testimony that children often describe genitalia using generic terms, and this child was using butt to describe female genitalia generally. If this court doesn't want to focus on that testimony, but it's the state's position.
Well, let me jump onto something that Judge Pullman asked you about, because as to her question, all of the discussion you and I are having would be irrelevant if anal intercourse comes within the ambit of sexual intercourse. Did you want to address that?
I do, and I've looked at Hatridge, and I think Judge Pullman is correct. It does lend some support for the idea that any touching, however slight, is sufficient to constitute the relevant element of the offense of rape of a child when the testimony is that an anus is involved.
Well, let me ask a more pointed. Is it the state's contention that for the purpose of this offense, that oral sex, anal sex, or vaginal sex all come within the ambit of sexual intercourse, as that term exists?
I think there's a lot of case law that supports the idea that sexual intercourse is a female organ and a male organ. And there is some case law that supports the notion that it all falls into the ambit of sexual intercourse. I think for the purposes of this case here, this court doesn't necessarily need to go there because the child's description really does fit that of a vaginal touching. Yes, Your Honor.
I'm just curious if we can I'm just curious to know what the state's position is. It sounds like we do have case law that might go either way, and I appreciate that you think we don't have to reach that, but it's interesting to me when I looked at the trial testimony that nobody was arguing about this. No one was suggesting I think that the arguments from CN's side was just that this didn't happen, that this child the 9-year-old was the aggressor, if anything happened, but kind of was just discounting the event as a whole. And then the state was arguing that something happened here, that sexual intercourse happened, but they were never clear about whether it was vaginal or anal or anything else. And so when the court makes its finding, it's a little unclear to me what the court's even finding. So I'm curious to know what the state's position is. Do you think we should interpret the statute as sexual intercourse being only vaginal intercourse?
Honestly, Your Honor, I would need to do a bit more research on it to more poignantly answer your question. Because I want to give you the right answer. I don't want to go off the cuff. And I think, as I said before, there's evidence to support both. In this case, it's my interpretation of what happened at trial, that the state was arguing that it was vaginal intercourse. And had only argued that it was vaginal intercourse, which is why I don't have that case law and I'm a bit unprepared for your question. That the prosecutor argued that, and it was my interpretation based on the investigator's testimony and the prosecutor's argument, that they were arguing solely for vaginal intercourse, and that's the juvenile court's finding as well. If there's no further questions, I would like to quickly address one thing. I do believe that Mr. Clark asserted in his opening that they were challenging the veracity of the victim. In his opening brief, in the defendant's opening brief, they explicitly stated they were not challenging the victim's veracity. And so that's an argument that's made for the first time at argument today, and I'd ask the court not to reach it. If there's no further questions, we ask that you affirm.
Thank you, Ms. Wheeler. Appreciate your arguments today. Mr. Clark?
Your Honors, I'm a little confused with that. I could be wrong. I don't at all remember that we were challenging the veracity of the credibility. It was my opinion that we were saying the only thing that we're challenging is the element there. So, but regardless, couple of just a few points I wanted to make in rebuttal. So the first one, it seems to me like if the court follows the state's argument, it's going to have to say or find that it has going to have to conclude that an anus is not soft. If that seems to be what the state's arguing, that, well, obviously he said soft, that can only mean a vagina because a butthole isn't soft. And that wasn't evidence that has been proven. It wasn't proven below, it wasn't discussed at all. And that is the state's burden to prove if they want to make that argument. Another point, it was talked about kind of the age-appropriate descriptions of what occurred, and absolutely, we totally agree that a 9-year-old and a 12-year-old boy, they know what a butthole is, regardless of whether he knows what a vagina is. I think it's probably fair to say a 12-year-old boy knows what a butthole is, and so for him to consistently say throughout, both at 9 and then 3 years later, his story does not change at all. At 9, he's saying, yes, you told me that I need to put my middle thingy in her butt, and that's what I did. I put it in there, I saw it. When we get to trial, 3 years later, it's the same exact story. She told me that I need to put my middle thing in her butt. That's what I did. As far as at trial, we did argue on page 915 of the record, in closing argument. I'll just read it. It says, I don't know, speaking about the officer, they say, I don't know where he got this. And it obviously meant that he was talking about her vagina. Well, he never spoke about her vagina. That's what Esty was saying the whole time. So basically, we did argue that, yes, the police officer said that, basically assumed that when he said soft, that meant vagina. But throughout the whole time, he pointed out in closing arguments, he said butt. He never said vagina. And so the elements were not there to find guilty of sexual intercourse. Let's see, what other points that I have. So, and yeah, so it's clear and consistent throughout. As far as the argument about the evidence, again, our position is not that his testimony was somehow erroneously admitted into the record, or that he should not have been allowed, or that even that the judge should not have considered his his testimony. That's not what we're saying at all. All we're saying is that what he said there does not establish enough of a foundation for the judge to be able to correctly rely on it. Even taking everything that he says, when he says that, well, I watched it and I saw that you said that it was soft. And so because of that, I'm saying I interpret that as meaning vagina instead of butt. We're saying that for the judge to, like, that is not a sufficient basis for the judge then to, okay, well, disregard the plain meaning of everything else that he said, correct 18 times and then 2 times at trial at 9 and 12. That's not a sufficient basis to then change the plain and ordinary meaning of what the victim was testifying to. Throughout, it's consistent. It's consistent throughout with placing his penis into her butt. And so, my time is running out, but we would just conclude and ask that the court find that that there was that the court erred in finding that sexual intercourse occurred when there was no evidence whatsoever of sexual intercourse actually occurring. So, if there are no further questions, we'll end, I guess.
Thank you, Mr. Clark and Ms. Wheeler. If you can come back, thank you. Well done today, Mr. Clark. Hope your first time arguing in front of the Court of Appeals was not too painful. You both did a great job, and I appreciate your briefing in this matter as well. We will take this case under advisement and render a written decision as soon as we can. So good to see you today. Thank you.
Thank
This
you.
court is in recess until 10:30.